Hey everybody, I'm David Crum, author and managing attorney at our law firm, and I want to take some time today to provide you with a little straight talk and give you some honest information about fathers' rights when you're facing a custody case in our state. And more importantly, what women most often do to defeat men's arguments for 50-50 custody. Now look, I've been a high-level divorce attorney and family law attorney for over 20 years. I'm the author of the book Confessions of a Divorce Assassin, which you can find on Amazon and barnesandnoble.com. And I lead the team here where everyone practices exclusively in the area of divorce and family law. I call this video Father's Rights, the good, the bad, and the bullshit, because I think that's about the most accurate title I can think of as it applies to what's being said right now about father's rights. So today I'm going to share with you the real inside information that relates to father's rights and how you can best prepare yourself for a case with custody issues here and to overcome the arguments women most often make against equal custody. So let's start with the good news. The good news is that it's a great state to get divorced as a father, especially if you have custody issues and especially if you listen to what I say in this video. See, the reason is that our state doesn't have any legal presumption as it relates to custody, and in fact, the judges here like to see as much shared physical custody as possible. Now, the bad news, if there is any, is that some time ago there was a legal doctrine that the courts used to follow called the tender years doctrine. And what that essentially said was that when children are younger, it's in their best interest to spend more time with their mother. Now, that doctrine has been abolished and it's not followed by the courts today, but the underpinnings of that. I'm talking about the actual thought processes behind that. That can still creep into custody findings in the modern era. So if you have a very small child, for example, who is the subject of your case, you need to be aware of this possible bias and you need to have very specific arguments in place to help overcome some of these prejudices. And that's something we'll talk about in a little bit. Now, the bullshit part of the father's right issue is that there are a lot of father's rights groups running around out there. And there's some divorce firms out there who are pretending like father's rights are some unique development in the law, or that they somehow exist independently of parents' rights in general. And the truth is there's no such thing as father's rights. Fathers have exactly the same rights as mothers in our state. But there's certainly danger in this messaging, which makes men sometimes think that there's some special rights they can assert in their custody cases. See, it seems to me that a lot of these father's rights messaging is just a marketing tactic for these firms to get more business. Now, I'm not saying that marketing is a bad thing at all, but the danger in this is that it's very misleading to men in terms of how these cases should actually be handled and how they should be preparing their strategy and communicating to the court about their custody case. I can tell you right now, I've litigated against some of these firms and it is a disaster for men when they lead with the idea that somehow they have a right to an equal custody arrangement. So one of the very easiest arguments that women make in defeating 50-50 custody is that the parents simply are unable to co-parent effectively, which is absolutely something that is required for a split custody situation. And the way that they most easily establish that is by showing communications that happen at the beginning of a case that relate to arguments, unreasonable demands, and flexibility when it comes to child visitation schedules. So the very first thing that you need to consider is how are you going to communicate with your wife, or if you're not married, with the mother of your children? I know this seems obvious, and I should not even have to say this, but I have seen too many cases in which a father completely blew up his custody case before it even started. Well, so what should you do? Well, the best thing to do is to pretend like every conversation you have, every text you send to your wife, every Facebook or social media post that you make is going to be reviewed by the judge who's going to hear your case. Because the truth of the matter is, that is something that happens all the time. That sort of evidence is used day after day in courtrooms all over the country to impact child custody scenarios. And I should know, because I've done it many times myself to limit a visitation with the parent in a case. So it is a good idea to be nice, and even more importantly, and I want you to listen to me very closely on this, to be accommodating and flexible at the very beginning of your case. Now, why do I say this? I'm not just saying that you should roll over and not have a say in temporary custody plan, but one component of having 50-50 custody is your ability to co-parent. And many times, men who get very aggressive about custody arrangements or refuse to be flexible at the beginning of the case, they ultimately get that used against them for a 50-50 custody split. Now, you do have to argue for as much time as possible while the case is pending, because that starts to establish a status quo. And if you have too little visitation, that will work against you as well. So it's a very fine line. And a good lawyer should be able to help you navigate that issue. The second argument that is made against a 50-50 custody arrangement is that father's schedule simply cannot accommodate it. Now, almost always this has to do with the father's work schedule and his inability to spend time with the kids during his periods of responsibility. So, another component of setting yourself up for success is getting your schedule in shape so that you can actually demonstrate to the court that a shared custody arrangement is appropriate. If it is possible to vary your workdays to better accommodate your visitation schedule, you should absolutely do that. You should also be committed to taking your children to extracurricular activities or sports activities during your periods of responsibility. Now, I know you can't always do that, so you should also have contingency plans in place that might include something like the kids' grandparents taking them or someone else helping you to accommodate the child's needs. What is not a good idea is proposing that your new girlfriend will watch the kids or take them to extracurriculars. While the courts are sympathetic that your time is your time with the kids, it's often possible for the other side to defeat shared custody by showing that you actually will not be able to be with your kids during your time. Also, even if you have historically not been able to spend that much time with your kids, you should start making the effort right now. The court is going to look at what the parties have done while the case is pending. So if your divorce case is pending for a long period of time, that will give you an opportunity to demonstrate that a shared custody arrangement can work. Now, in a number of cases in which I've represented mothers and argued that this is too little too late by the dad, the court has still recognized this effort and rewarded fathers for it. So it's never too late to get involved fully with your kids. The third mistake I want to talk about that many men make, and that unfortunately many fathers' rights law firms make, is not framing their proposed custody schedule in the idea of the best interests of the child. You see, the legal standard, as I've said, is always going to be what is in the best interests of the child. That legal standard trumps any rights that you think you have in these cases, and it'll always be applied by the court. So what do women do? They will often argue that a 50-50 custody arrangement is simply not in the best interest of the child. So again, the focus here should be on what you're adding as a parent. The most obvious arguments are that children are usually very bonded with both parents, that a father can provide a unique experience to the children. And some psychological studies have shown that a father becomes even more important to the same-sex children than a mother. So as your sons get older, there's actually some evidence to support the idea that it is more important for them to spend time with their father than with their mother. But this always has to be presented as being in the best interest of the child. Now, the final thing I want to talk to you about is how to select the right attorney that is right for your case. The first thing that I would suggest is not selecting a firm that is advertising as a father rights law firm, especially if they have a lot of advertising in the community. Now, I know a fair amount of attorneys that work for these types of firms, and they spend most of their time readjusting their clients' expectations because of how much this father's rights message is overplayed in their advertising. The other problem is that because these firms are always representing men, and they're known in the community for that, I believe the courts begin to take their attorneys' arguments less seriously because they're always arguing for 50-50 custody, that that's in the best interest of the child, regardless of the situation, and they start to lose credibility with the courts because they're always doing that. So what you should actually be looking for is someone who practices in the court in front of the judge that you're likely to be in front of on a very regular basis. And in addition to that, you do not need a bulldog attorney who often does more harm than good, but you do need an attorney who can stand up for you and say no when saying no is appropriate. One of the easiest things you can do is to imagine that you had to go to court and you were not allowed to say a single word to the judge, that only your lawyer was going to be able to communicate your position to the judge. Now, if you're not 100% confident that the attorney could do that effectively, you need to keep looking for an attorney. And finally, if you have a particular difficult case, or if you're going to be making a big ask to the court, you may consider hiring a female divorce attorney. Now, that recommendation, I realize, is colored with some cynicism and it sounds sexist, but I still think that on a deeper level, it is sometimes easier for a judge to consider a custody proposal more reasonable when it is made by a woman on behalf of a man rather than a man on behalf of a man. Okay, that's a lot for you to think about. If you're facing a custody case here, I really hope you pay attention to what I just taught you, because it will do wonders in improving your ability to get an equal time sharing custody arrangement in your case. Also, if you're considering hiring an attorney, you can contact our offices and we'll do a free evaluation of your case over the phone. That means we'll help you to discover what your best type of divorce would be, including uncontested, mediated, collaborative, or litigated divorce, and we'll help you figure out the roadmap to the successful resolution of your case and whether we can actually help you. Listen, I thoroughly enjoyed my time with you today, so hang in there because I know this isn't easy, and I look forward to meeting you.